Hello to all who are a part of the aging population and injured senior community. This is Stephen HEISLER, founder and CEO of the National Injured Senior Law Center, and you are listening to another episode of the Injured Senior Podcast. The Injured Senior Podcast is a weekly podcast dedicated to discussing issues of vital importance to the injured senior and elderly population and the aging population in general, and to their children, loved ones, and caregivers. I am recording this in October of 2020. It is wonderful outside. It's beautiful. The leaves are turning red and yellow and all the beautiful colors, purple. It's also October, as I said. October the 9th is the birthday of John Lennon. For all you Beatles fans, I'm a huge Beatles fan, and John Lennon was my second favorite Beatle. First favorite was Paul McCartney, but John would have turned 80 on August the 9th. We lost him too soon. I can't believe it's been 40 years. So all you seniors out there who love the Beatles, let me know who your favorite Beatle was. Anyway, we are sponsored by the National Injured Senior Law Center, the legal advocates on behalf of seniors, elderly, and the aging population when they've sustained injuries, conditions, or diseases due to the negligence of others. Contact the Law Center at www.injuredseniorhotline.com. Okay, so today our topic is workers' compensation, specifically the 6 rules to follow after a job injury. Here is an interesting statistic, my friends. According to the National Council on Aging, more than 40% of Americans 55 and over are employed, which comprises 1/4 of the U.S. labor force. Yes, 25%, more than you probably thought. And the aging population is the fastest growing segment of the U.S. workforce. So it's continuing to grow by leaps and bounds on a yearly basis. In fact, according to the U.S. Bureau of Labor Statistics, the number of American workers aged 55 or older more than doubled from 1992 to 2017. Wow. So if you're working and you're a senior, you are definitely not by yourself. I can tell you that. There's a lot of other seniors who are working as well. I mean, I'm 59, and by the way, I turned 59 on September the 16th for all of you who are keeping score. And I do not plan, being 59, to hang up my spikes anytime soon. So there are many more seniors in the workplace. It's no surprise that older individuals have years of wear and tear on their bodies and might be more susceptible to getting hurt on the job. And the statistics bear it out. In 2009, injured senior community, approximately 211,000 non-fatal occupational injuries and illnesses among workers over 55 resulted in missed workdays. And that is according to the CDC. That's 17% of the total of 1,238,490 missed workdays because of job injuries for all workers. 94% of the injuries that occurred to workers over age 55 are categorized as acute traumatic injuries. If you're 55 or older and suffer an injury on the job, here are 6 rules to follow after a job injury. Number 1, report it immediately, preferably in writing. Ladies and gentlemen, I cannot tell you how many workers lose their workers' compensation cases because they failed to timely report the injury. Put it in writing. Get it date stamped, or send it certified if you're mailing it in, and be careful how you phrase the description of the accident. if you describe it in an ambiguous fashion or you give the wrong description, it could come back to haunt you. And I promise you that because I've seen it. Again, I've seen it numerous times. Also, do not leave out any of the body parts that you injured. Even if it's a minor injury to a body part, that could get worse. And if you don't put it into your written notice of an injury, that could come back to bite you later on in the case. The employer's insurance company will fight you tooth and nail to exclude any injuries from the claim. Number 2, be sure to get the names of all witnesses. If the employer disputes that an accident occurred, and they do that a lot, you may need the witness to corroborate that the accident occurred. So make sure you take notice of anyone who had seen the accident, talk to them and see if they can support your claim or support that it happened. Number 3, see a medical professional immediately. Another big reason why workers lose their cases. The longer it takes for you to get treated or evaluated by a doctor, the harder the insurance company will fight you to deny you your benefits. They simply say, well, if he was really hurt, he would have gotten immediate medical attention or timely medical attention. So how do we know that, 1, the person was really injured, and 2, maybe something happened in between the time when they alleged they got hurt and when they finally got medical treatment. So the sooner you get it documented, the better. Trust me. If you don't get medical treatment after a job accident in a quick fashion, the insurance company treats it like it did not happen. Also, be sure to relate to your doctor what happened and make sure you mention all the body parts that were injured. So the insurance company scrutinizes the medical records, and if the report does not mention that it happened at work or what body parts you injured, or you leave out a body part, or all the body parts that you injured are not included in the medical report, your case can be in trouble. Also, make sure that the description that you give to the medical professional about how it happened is consistent with what you put in the accident report. And if you at some point give a statement or file a claim with the state agency, make sure that the description of the accident is consistent throughout, because if it's not, the employer's insurance company will fight it. If it goes to a hearing, they will cross-examine you and say, well, you said this one thing to the doctor, and then you said something else when you filed your accident report. So what is it, sir or ma'am? I think you get my point. Now, number 4, file the claim with the Workers' Compensation Commission or Industrial Compensation Board. Every state has a different name for the state agency that oversees workers' comp. In Maryland, it's called the Maryland Workers' Compensation Commission. If you don't file your claim with the Maryland Workers' Compensation Commission, if you're in Maryland, or the state agency that handles workers' compensation throughout the United States, you are putting your claim in serious jeopardy. And let me tell you why. So every legal situation, every legal case has what's called a statute of limitations. The statute of limitations is the period that you have to officially file your claim. And if you don't do it within that period, your claim is time barred. You can't you can't move forward with it. Now, to find out what the statute of limitations is for your state, just go ahead and go online and type in statute of limitations for workers' compensation cases in Tennessee or in Indiana. In Maryland, it's 2 years. And the insurance company will do everything they can to kind of conceal that you have to file a claim with the Maryland Workers' Compensation Commission if you're in Maryland, or the state agency in other states, because if you file the claim and they deny you any benefits, you have the right to go to a hearing before an independent judge. If you don't file a claim, and you miss the statute of limitations and you have a dispute, you don't have any recourse. So that's really important. Number 5, don't give a recorded statement to the insurance company for your employer until you've spoken to an attorney. If you give a recorded statement, they're asking you questions, you might not know the answer, or you might be nervous or might not have the greatest memory. So do not give a recorded statement unless you've consulted with an attorney, a workers' compensation attorney, and you either have that attorney on the phone call with you or you just refuse to give the statement. You're not required to give a statement. And number 6, look, I'm an attorney. This is the Injured Senior Podcast. The bottom line, though, is I'm trying to give you good, sound legal advice on issues that are pertinent to the senior and elderly and aging population. I think it is in your best interest to at least speak to an attorney to get an assessment of your case and advice on what you should do. You don't have to hire the attorney. I think it's in your best interest to hire the attorney. The great thing about hiring a workers' comp attorney is that they take it on contingency. So they only get paid if you get paid for your lost wages or for any permanent disability, usually at the end of the case. So you don't have to pay any money up front. And as my father would always say to me when I was a teen and young adult, you don't know what you don't know. And there are so many caveats and idiosyncrasies about workers' compensation laws. You're probably not going to really know much about what the law is. You really need to have someone who is a specialist in workers' compensation who can give you the proper advice and representation that you need. You got to remember, the insurance company is looking to defeat your case, or at least do everything in their power to limit the amount of benefits that you can get. And if it's a really serious case, really serious injury, this could affect the rest of your life. So you got to make sure that you get it right. And if you don't do the things that need to be done to keep your case alive, you're going to end up without any benefits at all. Okay, well, I hope that this was helpful. If you have any questions, you can shoot me an email at any time at steve@injuredseniorhotline.com. I respond to every email. I will talk to you soon. I will see you on our next episode. Have a wonderful day. Goodbye, everybody.
Thanks for listening to the Injured Senior Podcast with Steve H. HEISLER. If you enjoyed the podcast, please rate, subscribe, review, and share on Apple, Google, or wherever you get your podcasts. To find out more or to get help anytime, go to injuredseniorhotline.com or call 855-622-6530. We'll see you next time.